K. Odeibo, Esquire.
Yes.
Chris Odeibo, Esquire.
Yes.
Efud Okoi, Esquire.
Efud Okoi.
Okoi, O-K-O-I, my lord.
Yes.
Esquire.
Yes.
Kenechiku Aze, Esquire. Daniel Ibebu, Esquire.
Daniel Ibegu.
Esquire.
Yes.
SP Asheka, Esquire. Asheka, my lord. A-S-H-I-E-K-A-E, Asheka.
Yes.
Nifemi Aje, Miss.
Nifemi Ajimis.
Very well, my lord, sir. Ifeanyi Igwawu. My lord, I will spell Ugwawu so that I will not be charged for misspelling, mispronunciation.
Yes.
E-T-W-O-N-W-U.
Yes.
Esquire, my lord.
Yes.
And Adekola I Olawe. We are most grateful, my lord.
Yes.
My lord, we have a charge. My lord, our charge is dated.
There's something I want to say. What about the accused? What is the position?
My lord, that is my. I was just trying to lay the foundation, my lord, before I get there.
Yes.
My lord, I'm surprised the accused is not in court, my lord, because he has been served with summons.
Yes.
A summons has been served on the accused person, my lord,
Yes.
for him to appear before this honorable court.
Yes.
My lord, they even exhibited it in the process they filed. So it is not in dispute that the accused person have not been served with the copies of the summons. And my lord is not here.
Yes. You have been served with the process this morning.
Sir?
You have been served with the process?
No, my lord, what I'm saying is that the summons,
Yes.
they have been served. What I'm trying to say, my lord, is that the summons have been served on the accused persons.
Yes.
And that summons, they even exhibited in their process. So the issue of service is not an issue, my lord. It means that the accused person have been served with the summons, and he is not here.
Yes. In other words, you are saying in the process they are filed.
Yes, sir. They exhibited the summons, my lord.
Yes.
So the issue of service does not even arise. It means that he has been duly served and is not here.
Yes.
My lord, in the circumstances, my lord, we humbly apply that a bench warrant be issued against the accused persons, my lord, for disobedience of the order of this honorable court. This court is a court of competent jurisdiction. This court is a creation of the Constitution. And it has compulsive powers, my lord. To command the appearance of an accused person who flagrantly disobey the order of the court.
Yes.
My lord, my brother has a brother beside him, the oracle.
My lord, sir, we apply that a bench warrant be issued, my lord. And my lord, we humbly apply that we can even stand the matter down, that a bench warrant be issued, so in the next 2 hours, the accused person should be produced, so that we can make progress in this case, my lord. My lord, that's our humble application. 2 hours will be sufficient, my lord, to enable us execute the arrest warrant for his counsel to even produce him, my lord.
Yes.
The counsel have access to his, he has access to his counsel, my lord. So 2 hours will be sufficient, my lord, for him to produce the accused persons. My lord, that's our humble application, sir.
Yes.
My lord was more grateful, sir.
Yes, defense.
Thank you, my lord. My lord, the application before you should be expunged from the record, inclusive the appearance.
Should be expunged, right?
Should be expunged, my lord. Thank you, sir. The basis
Yes.
the basis of our application is simply that the person making that application does not possess the local standing to make that application before your lordship.
In other words, you're saying the person making the application for bench warrant is...
He doesn't possess the competency to even appear in the capacity he appeared before your lordship.
Yes.
My lord, for him to be able to appear before your lordship as a prosecutor in this case,
Yes.
there need to be a sitting attorney general of the federation. There must be an incumbent in place.
There must be an incumbent attorney.
Incumbent attorney general, my lord.
Yes.
This is fortified by the provisions of Section 24, subsection 2 of the Code of Conduct Bureau and Code of Conduct Tribunal Act.
Section 24, subsection 2
Very well, my lord, sir.
of the Code of Conduct Bureau and Tribunal Act.
Very well, my lord, sir. May I, with the leave of the tribunal, read? My lord, my brother Jacob is asking me whether I'm angry. I told him that I normally go to court with an empty stomach. So I'll be angry and hungry. I'm very sorry, my lord. My lord, may I, with the kind permission of your lordship, read?
Yes.
The same section provides, my lord, that prosecution for all offenses referred to in this act shall be instituted in the name of the Federal Republic of Nigeria by the Attorney General of the Federation or such officer in the Federal Ministry of Justice as the Attorney General of the Federation may authorize to do so. As the Attorney General may authorize to do so.
Yes.
In order to assist me in the interpretation of this provision, my lord,
Yes.
I went further to the interpretation provision of this honorable tribunal. Particularly, my lord, interpretation
Paragraph 18.
of the third schedule to the Act.
Third schedule.
Of the third schedule to the Act.
That's CCV&T Act.
Very well, my Lord, sir. I'm grateful, sir.
Yes.
And with the kind permission of the tribunal again, may I read?
Yes.
This is what the Act says. In these rules, the prosecutor means Attorney General of the Federation or any other person authorized by him pursuant to Section 24 of this Act to conduct prosecution for an offense before the tribunal or assist him therein.
Yes.
Where there is no principle. My Lord, it is right that you cannot put something on nothing and expect it to stay. Similar provision that is similar to this, that of the Code of Conduct, my Lord, have been subject of interpretation by the Supreme Court. In the case of AG Kaduna State versus AG Federation versus Hassan. I'm sorry, my Lord, I'm very sorry.
AG Federation?
AG Kaduna State versus Hassan.
AG Kaduna State versus Hassan.
Versus Hassan.
Yes.
My Lord, it is reported 1985.
Yes.
2.
Yes.
Nigerian Weekly Law Report.
Yes.
Part 8.
Yes.
Page 483.
Page 483.
Particularly at page 486.
Yes.
Ratio 20, 21 and 22.
Yes.
Paragraph F, G and H.
Paragraph F, G, and H.
This is what the Supreme Court had to say. Faced with the similar circumstance as the one before your lordship.
Yes.
My Lord, the Supreme Court said that the provision of Section 191,
Yes.
which has to do with the power of Attorney General of the Federation to institute nolli prosecute, either to continue or discontinue,
Yes.
that power can only be exercised where there's an incumbent Attorney General.
That's regarding nolli prosecute.
Nolli prosecute, very well, my Lord. The Supreme Court went further to say. The Supreme Court said so. And the Supreme Court said further that that's at paragraph 21. It says that the power of Attorney General under Section 191 are personal to him. Is born out of the inclusion of the words. That is there for reference. In paragraph 22 particularly, my Lord, it says that the offices of the Director of Public Prosecution
Yes.
and Solicitor General are existing offices by virtue of Section 275 of the 1979 Constitution, and that the Solicitor General has no power to exercise the power of Attorney General under Section 191 of the 1979 Constitution. In fact, my Lord, the Supreme Court went further to say, before such delegation can take place, like in this case, the man purporting to be having been delegated with that power, there must be an incumbent. There must be an incumbent Attorney General in the office who can be the donor of such power. My Lord, in order to bring us out of the dilemma of interpretation, the same act have provided under paragraph 18 of the third schedule, that what we mean by prosecution or prosecutor here is that an attorney general should be the one to delegate anybody to assist him. There is no attorney general. I urge your lordship to expunge his appearance. If our submission receives the favor of this tribunal, it then means that that application is a nullity, because you cannot put something on nothing and expect it to stay. It is tried in law. Again, my lord, the application made by the Learned Council purporting to be acting for the Attorney General is grossly misconceived, and same should not even be given.
The application of the prosecution is grossly misconceived.
Very well, sir. In view of the fact that my learned friend, Hassan, a very good friend, of course, is aware of a pending suit in the Federal High Court.
My lord, with due respect to the senior advocate, my lord. My lord, you can't bring that issue here, my lord, because I'm not even aware of the pending suit the senior advocate is talking about.
I'm entitled to member and please. You have your own time. You respond to it.
My lord, with due respect to the senior advocate, my lord, you can't be giving evidence here, my lord. That amount to giving evidence, saying that I'm aware of the suit.
My lord, that is not how it's done. I am making an application. I'm making my submission. I'm on my feet. He has his time to respond to my whatever position I compound in law. My lord, he cannot interject. That is not good practice.
Yes, let's proceed.
Thank you, my lord, sir. When he was making his application, I knew he had no jurisdiction or local statute to make that application. I had exact patience for him to land so I can respond. This is court of law. This is court of justice. It's for everybody.
My lord, sir, with due respect to the senior advocate, well, I have a right to object to the manner of address, my lord.
Yes.
So, my lord, if he's giving evidence from the bar, my lord, I can object to it. This amount to giving evidence that I'm aware of the pending suit. How will I be aware? He has to prove it by giving evidence, which means he'll be giving evidence from the bar. My lord, with due respect, my lord, I object to that line of argument, my lord, and I want my lord to expunge that line of argument. With the greatest respect, sir.
My lord, by virtue of section 122 of the Evidence Act, 122, my lord. Thank you, sir. Evidence Act 2011. This tribunal is empowered by virtue of that section to take judicial notice of the said ruling that we are referring to in the circumstance.
Which ruling?
My Lord, sir.
We're not aware of any ruling here.
My Lord, it is straight to me. Your tribunal, sir, has the power to take judicial notice.
We are making reference to a ruling.
Very well, my Lord. The order of the Federal High Court in suit number
You are referring to what?
Sir?
You are referring to what?
Very well, my Lord, sir. I'm referring to the ruling of the Federal High Court, duly served on this tribunal.
Yes.
Via suit number FHC slash ABJ slash CS, sorry my Lord, CS,
Yes.
slash 775 slash 2015, 2015.
2015.
Very well, my Lord, sir. Between Dr. Bukola Saraki, Abaka Saraki,
Yes.
versus Federal Ministry of Justice,
Yes.
the Chairman Code of Conduct Bureau,
Yes.
the Chairman Code of Conduct Tribunal,
Yes.
and Barrister M.S. Hassan as defendant respondent.
Yes.
My Lord, it is our submission that
Yes.
that the ruling of the Federal High Court
Yes.
duly served on this tribunal,
Yes.
as well as other processes,
Yes.
automatically operates as a bar to this proceeding.
Yes.
The authority for that, my Lord, is the case of Doma versus Ogiri.
Sorry?
Doma versus Ogiri.
Ogiri?
Ogiri, my Lord, I'll provide the citation. I'm just citing through. And Ojukwu versus Lagos State. Versus Government of Lagos State, Governor of Lagos State. Sorry, my Lord. Ojukwu versus Governor of Lagos State. My Lord, we're browsing through the citations. We'll provide the court with the citation. To the effect that, my Lord,
Yes.
the Court of Appeal in Doma versus Ogiri have this to say, that when issues have been joined in a matter, the mere service of that process automatically operates as a stay. Without that much ado. The court went further to say that the degree of compliance is more on government or federal government agencies or parastatals, as in this case.
The degree of compliance?
Yes, sir. Madam, sir. Yes, sir.
Yes.
My Lord, I have the citation and the hard copy of Ojukwu versus Lagos State. It is reported in 1986, one Nigerian Weekly Law Report, 1986, one Nigerian Weekly Law Report, page 621,
621, yes.
particularly at page 623,
623.
very well, 623, my Lord.
Yes.
Which says, it says, the essence of rule of law, my Lord, I with kind permission of the tribunal, read.
Yes.
Thank you, my Lord, sir. The essence of rule of law is that it should never operate under the rule of force or fear. After a defendant has been notified of the pendency of a suit seeking an injunction against him, even though a temporary injunction be granted, he acts at his peril and subject to the power of the court to restore the status wholly irrespective of the merit, as may be ultimately decided. No one, in bracket, including government, is entitled to take the law into his hand. My Lord, this case is all in force with what is happening here. Aware of the pendency of a suit. A ruling has been given. It has been adjourned. And they are saying they want your lordship to continue in a suit which you have been joined as a defendant and respondent.
Yes.
My Lord, in Doma versus Ogiri, the citation is now ready, my Lord. It's 1997, my Lord. 1, Nigerian Weekly Law Report. 1997, 1, Nigerian Weekly Law Report.
Yes.
Part 481, page 322, at page 343.
Yes.
My Lord, let me quickly sum up my submission. Assuming without conceding that there is a sitting attorney general, there is no pending suit, my learned brother has been caught up by the rules of procedure of this honorable tribunal. Very well. My Lord,
My Lord, sir, with due respect, I didn't like interjecting, but I don't have to do that, my Lord. My Lord, we were served with a preliminary objection this morning, on which we are working on. And basically, the lesson advocate, what is arguing on is on his preliminary objection. Is dwelling substantively on preliminary objection.
Yes, because
my Lord, so I don't know really because the issue is very narrow.
yes.
Can you raise an objection in absence of your client? The law is very clear on it, my Lord.
Yes.
sorry, my Lord, let me finish so that he can answer it. Give me his own submission. I'm failing to understand the direction he's going through. He seems not to have gotten my application. My application is to the fact that he is making an application he has no local standing to make. That's my first application.
Learned SN.
Sir, thank you, sir.
Let's do things properly.
Very well, sir.
The chairman has taken the pains to give you this audience because of the respect we have for your status.
Very well, sir.
Ordinarily, you know, we ought not to have granted you audience in the absence of your client in court. We're talking in bracket, isn't it? Now, listen.
Very well, sir.
Why don't you address the issue that has been raised due to his non-appearance? You concentrate on that. Don't go into the substantive issues that are involved. Leave that to the courts to decide it.
My lord, I take the hint of the tribunal.
Is that okay?
I'm most grateful, sir.
Pardon?
I take the hint of the tribunal, and I'm very grateful, my lord.
Let's
The
concentrate.
only thing is that my friend will be asking me for consultancy now, that you have given me a very good advice. My lord, as relates to his application for bench warrant, in addition to my earlier application, which I adopt in responding to that he's not competent to make that application. Because there is even no charge before your lordship. There is no charge. My lord, the Supreme Court, in Fahemi versus AG Lagos State, number 1, 1989-3, Nigerian Weekly Law Report.
In office. Right now, he's even still in office, my lord.
Yes.
And my lord is also not in dispute. The Solicitor General of the Federation instructed me to file this action as an officer in the office.
Yes.
My lord, we also rely on Section 11 of the Interpretation Act.
Yes.
So, my lord, it's a clear misconception, with due respect to the national advocate. This argument, my lord, our submission, has clearly nullified all the arguments raised by the national advocate in that regard, my lord. So, my lord, our submission is that the Solicitor General of the Federation is mandated by law. We further submit that the Solicitor General of the Federation is mandated by law, my lord, to perform the functions, duties, and exercise the powers of the Attorney General by virtue of Section 4 of the Law Officers Act. The Solicitor General of the Federation, my lord, we submit, is mandated by law, my lord. It's a provision of the law, my lord, that cannot be waived.
Yes.
My lord, mandated by law, my lord, to perform the functions, the duties, and exercise the power of the Attorney General of the Federation.
We have taken that already, Counsel.
I'm grateful, my lord. So the law cannot create a vacuum, my lord. It's our submission that the law cannot create a vacuum. That was why that Section 4 is there. My lord, we also further submit, my lord. We also rely on Section 11, my lord, subsection 2 of the Interpretation Act. Section 11, subsection 2.
Mr. Hassan, you are just repeating yourself over. Maybe because Rotimi is sitting next to you and disturbing you. Let's try and keep going round, saying one thing. You've said enough.
I want to overkill, my lord, so that I want to cite all what I have.
Rotimi, allow him to concentrate.
As God pleases. My lord, it's allowed in law, my lord, that counsel, we have to make consultations. Yes, sir. That is the essence of law, my lord. My lord, we rely on Section 11, subsection 2 of the Interpretation Act.
Yes, Section 11, subsection 2.
Of the Interpretation Act, my lord, that says that provides that a reference in any enactment to the holder of an office shall be construed as including a reference to a person for the time being appointed to act in his place, either as respects the functions of the office generally or the functions in regard to which he is appointed, as the case may be. So while an officer is acting in an official capacity, the Interpretation Act says that he is acting and performing the duties of that office. I'm grateful, sir. My lord, the provision of the case of Attorney General versus Hassan versus Attorney General of Kaduna State, my lord, that was heavily relied upon by the senior advocates, my lord, was in respect of a noli, my lord, not institution of action. That is one. My lord, and then, my lord, the provision of Section 4 of the Law Officers Act was not in Kaduna State. The Law Officer Act is applicable to the laws of the Federation, and it specifically mentioned the Solicitor General of the Federation. My Lord, that was why they were having difficulty in that Hassan versus Antonija. If the Law Officer Act is applicable to Kaduna State, my Lord, decision will not have arisen. So, my Lord, our submission is that the case of Hassan versus Attorney General of Kaduna State is not relevant to this present case. My Lord, we also further submit, with great respect, my Lord. We rely also on the Section 24, my Lord, of the Code of Conduct Bureau and Tribunal Act.
Section, paragraph 24?
My Lord, my Lord, Section 24, my Lord. Section 24 of the Code of Conduct Bureau and Tribunal Act.
Yes.
My Lord, subsection 3, my Lord. Section 3, the proviso to subsection 3, my Lord. The proviso to subsection 3 of section 24.
Yes.
My Lord, that provides that, provided that the question on whether any authority has been given in pursuant of this subsection shall not be inquired into by any person. My Lord, you cannot even challenge the competency. It's the law. You cannot even challenge the competency of my appearance before this honorable court. Because that law, you can't challenge it. It's a provision of the law, my Lord.
Yes.
My Lord, it's our submission that the objection cannot be raised in absentia, my Lord. My Lord, we also further submit that the case of Lagos Federal High Court that the Landed Senior Advocate is citing, my Lord, the injunction that he has failed to obtain in Federal High Court, he now wants to obtain that similar injunction here. The court cannot look into that. He failed to obtain the injunction in the Federal High Court in Abuja. He now wants to obtain that injunction here to stall the trial of this case. My Lord, we honorably submit that the court should not accede to their request. My Lord, is also on record, my Lord. He applied for interim injunction, my Lord, in the case he cited, Dr. Saraki at the Federal High Court, which the court refused to grant that injunction. That injunction was not granted, my Lord. Now he's now coming here to obtain the similar injunction. It's not the law, my Lord, that foreign shopping. The law does not encourage foreign shopping. You didn't get injunction somewhere. You are now coming here again to get another injunction. That's foreign shopping, my Lord. We urge this honorable court to...
Yes.
My Lord, it's also our further submission. In respect to this same case, my Lord, that the Federal High Court is right in law, that the Federal High Court cannot even compel this honorable court, because this court is a court of law, recognized by the Constitution. So the Federal High Court even lacks power to compel the appearance of this honorable court before the Federal High Court. The Federal High Court doesn't have a supervisory jurisdiction over this honorable court. The appeal from this court, my Lord, from this tribunal, goes to Court of Appeal. My Lord, there are courts of coordinate jurisdiction.
In other words, the Federal High Court and the Court of Conduct Tribunal are of coordinate jurisdiction.
As the court places, my Lord. And they are superior courts of record, recognized by the Constitution. Constitutionally recognized. So supervisory jurisdiction of the Federal High Court is on inferior tribunals, like Board of Customs, Board of Inland Revenue. Those are the inferior tribunals that they have supervisory jurisdiction over, my lord. But not a court of competent jurisdiction as in this court.
Yes.
My lord, we just also want to just add one more, my lord, before I take my seat. My lord, I also want to rely on the case of Attorney General of Anambra State, my lord, versus Uba, 2015, my lord. 15 Nigerian Weekly Law Report. 2015, my lord.
Yes.
15 Nigerian Weekly Law Report.
Yes.
Part 947, my lord. Part 947. Page 44, my lord, at 67.
Yes.
My lord, the Supreme Court, I will just read the Court of Appeal, my lord. The Court of Appeal said, condemned, where his lordship condemned the attempt by a suspect to rush to court to prevent his investigation and eventual prosecution. My lord, their lordship stated, for a reason, for a person, therefore, to go to court, to be shielded against criminal investigation and prosecution, is an interference of powers given by the Constitution to law officers in the control of criminal investigation. My lord, the plaintiff has no legally recognizable right to which the court can come to his aid. His claim is not one that the court can take cognizance of, for it has disclosed no course of action. The plaintiff cannot expect a judicial fiat preventing a law officer in the exercise of his constitutional power. This issue, my lord, the court said, this issue amounts to no issue. He can't come and prevent us from exercising our constitutional powers. Neither can he stop this honorable court from exercising his own constitutional powers. And my lord, the accused cannot sit in the comforts of his chambers and say, my lawyer will do it for me. It is not known to law, my lord. My lord, I will rely on the case of Alinta by the Federal Republic of Nigeria, where the Court of Appeal said the accused that this is a criminal case. It's not a civil matter. That the accused cannot sit in the comfort of his quarters and say, my lawyers will do it for me. It's not known in law, in law, my lord. My lord, I will give the citation, my lord, of Alinta, because I personally handle Alinta, my lord, to Court of Appeal. And the Court of Appeal said, you can't sit in the comfort of your quarters and be challenging jurisdiction of this honorable court. That you must come to court. So, my lord, a court summons have been issued, my lord, and we urge my lord to issue a bench warrant for the arrest of the accused persons, my lord. My lord, finally, my lord, we also further submit, with due respect, my lord, that we rely on the case of Kalu vs. Federal Republic of Nigeria, 2014. Kalu, my lord, as Uzo Kalu. Kalu vs. Federal Republic of Nigeria, my lord, 2014. 1 Nigerian Weekly Law Report.
Yes.
Part 1389, my lord. Part 1389. Page 479, my lord. Page 479. At 554. My lord, finally, and Zurike versus Federal Republic of Nigeria, sir. My lord.
Zurike?
My lord, 2013, my lord. Zurike versus Federal Republic of Nigeria, my lord.
Yes.
2013, my lord. 2013. Part 1361, my lord.
Zurike versus Federal Republic of Nigeria, 2013?
Yes, 2013, my lord. Yes. 2013, my lord. Part 13. Zurike, my lord, versus Attorney General of the Federation, sir. Zurike versus Attorney General of the Federation, my lord. 2013. 10 Nigerian Weekly Law Report, part 1361, my lord.
Yes.
Page 105. My lord, where the Supreme Court specifically said that even where there's an order, finally, my lord, where the Supreme Court in those cases stated that even where there's an order, you can't stop this honorable court from proceeding, my lord. An order of the Federal High Court cannot stop this honorable court from proceeding. Even where there's an order stopping this court, the Supreme Court have stated clearly that this court cannot stop the proceedings. So, my lord, we urge this honorable court to issue bench warrant for the arrest of the accused persons, my lord, as objection cannot be taken in absentia, my lord.
Yes.
I'm grateful for my lordship's indulgence. I'm grateful, sir.
With greatest humility to my noble lords, my lord, may I seek the indulgence of the tribunal?
Yes.
To state that my lead counsel, J.B. SAN, is in court and in tribunal and will be proceeding with reply on point of law. I'm most grateful, sir.
That's all right.
My lords, may I sincerely apologize for coming late.
Yes.
We thought that there would be no proceedings today in view of the order of the Court of Appeal, and I'd asked him, out of great respect for this honorable tribunal, to come and show the order of the Federal High Court, asking your lordships to tarry a while until cause is shown on Monday, just 2 days away, or 3 days away, so that the issues can be better ventilated on. I have been shown the points made by my learned friend, Mr. Hassan, a good friend of mine, and I'd just like to reply on points of law. Now, before proceeding, my lord, I think it behoves on me, as someone who has perhaps spent a few years in this profession,
Yes.
to say that these proceedings before your lordship is at a tangential point of our democratic governance. There is an interplay of all the arms of government, the executive, the judiciary, and the legislature. And therefore, great care must be taken for us to keep our democracy. The only point which we need to say, flowing from what has been said, is that your lordship should discountenance all the submissions so ably made by the prosecution.
Yes.
The simple point, this only point at stake here, is that rightly or wrongly, there is an order of the Federal High Court and he will not find and cannot find any authority of any court which will encourage this tribunal to disregard that order.
Yes.
I'm grateful for my Lordship's indulgence. I'm grateful, sir.
With greatest humility to my noble lords, my Lord, may I seek the indulgence of the tribunal
Yes.
to state that my lead counsel, JB Daud, SAN, is in court and in tribunal and will be proceeding with the reply on point of law. I'm most grateful, sir.
That's all right.
My Lord, may I sincerely apologize for coming late.
Yes.
We thought that there would be no proceedings today in view of the order of the Court of Appeal, and I'd asked him, out of great respect for this honorable tribunal, to come and show the order of the Federal High Court, asking your lordships to tarry a while until cause is shown on Monday, just 2 days away, or 3 days away, so that the issues can be better ventilated on. I have been shown the points made by my learned friend, Mr. Hassan, a good friend of mine, and I'd just like to reply on points of law. Now, before proceeding, my Lord, I think it behoves on me, as someone who has perhaps spent a few years in this profession,
Yes.
to say that these proceedings before your lordship is at a tangential point of our democratic governance.
Yes.
There is an interplay of all the arms of government, the executive, the judiciary, and the legislature. And therefore, great care must be taken for us to keep our democracy. The only point which we need to say, flowing from what has been said, is that your lordship should discountenance all the submissions so ably made by the prosecution.
Yes.
The simple point, this only point at stake here, is that rightly or wrongly, there is an order of the Federal High Court and he will not find and cannot find any authority of any court which will encourage this tribunal to disregard that order. There is none in Nigerian jurisprudence that disregard the order of the Federal High Court, one of the courts known to the Constitution. It's not fair to come and lead the tribunal astray. Whether the order of the Federal High Court is right or wrong, what is important is that there is an order that has been served on this tribunal.
Yes.
And the only thing that can be done with profound respect is to go and discharge the order. Heavens will not fall. But to desecrate the temples of justice by urging this tribunal to proceed in disregard of an order, we don't know what the consequences will be.
Yes.
So I urge your lordship, there is no need to cite too many authorities. It's a very trite, simple point.
Yes.
And Monday is not too far away. Let us tarry a while and be responsible handlers of the due process of law. And then we will come back. No one is afraid of prosecution. But these are rights that are perceived. And whether they are right or wrong, only the court and your lordships will decide that. But these things follow a process. So I urge you to discountenance their submissions, adjourn this matter to a date when we would have returned from the Federal High Court. Then we proceed. Thank you, my lord.
So we will rise for 2 hours. We'll come back by 1:30. Yes. Okay, we want to say that those authorities that have been cited, we want to use the authorities cited already. We want to use some of the books that you have cited. You provide us with the copies of the authorities you cited. Raised by counsel for the prosecution and the defense is whether there is an incumbent attorney general who could validly and constitutionally empower the prosecution to initiate the prosecution of this matter. The second issue is as regards the non-appearance of the defendant respondent in this case, Dr. Bukola Saraki, the Senate President. And the third issue in contention is the issue of an existing court order from the Federal High Court. We'll take these issues one by one. Issue number one, on the issue of initiation of proceedings by the Attorney General of the Federation, we have taken notice of the fact that there is no Attorney General at the present time. It is our considered opinion that that does not in any way preclude or exclude any officer of law in the Federal Ministry of Justice or its statutory body from initiating or commencing criminal proceedings. In the case of this tribunal, paragraph 1 of the third schedule to the Code of Conduct Bureau and Tribunal Act provides the mode of instituting action before the tribunal as follows. The trial of offences under this act shall commence by way of an application supported by a summary of evidence affidavit to the tribunal by the prosecutor. The case cited by the learned SAN in Attorney General vs. Hassan, 1985, 2 Nigeria Weekly Report, is a Supreme Court decision and a locus classicus, and it relates to the exercise of the power of nolle prosequi by the Honorable Attorney General, which personally requires the direct intervention or involvement of the person of the Attorney General himself. Obviously, a nolle prosequi is and cannot be seen or equated on the same pedestal as commencement of proceedings or trial of criminal matters. We must try to distinguish nolle prosequi and commencement of trial. It is the belief of this tribunal that the powers to initiate proceedings are further enhanced by the provisions of Section 2 and Section 4 of the Law Officers Act, CAF LA, Laws of the Federation of Nigeria. In the absence of Attorney General, the Solicitor General or any officer in the chambers of the Attorney General can exercise such powers or duties of the Attorney General, relating to institution of criminal proceedings. See also Section 24, subsection 3 of the Code of Conduct Bureau and Tribunal Act, which said prosecutions for all offenses referred to in this act shall be instituted in the name of the Federal Republic of Nigeria by the Attorney General or such officers in the Federal Ministry of Justice as the Attorney General may authorize. With regard to the issue of non-appearance of the defendant respondent, it should be noted that criminal proceedings were filed at the Registry of the Code of Conduct Tribunal on the 14th of September 2015, and we observe that there is proof of service acknowledged by one Ibrahim El Sudi, Special Advisor on Legal and Constitutional Matters to the Senate President, who signed and collected the tribunal processes on the 16th of September 2015. It is also a record that the defendant respondent, in reply to the summons of the tribunal, filed a memorandum of conditional appearance dated and filed on the 17th of September 2015. With the response, the respondent's defendant cannot claim not to have been duly put on notice. On the issue of an existing court order barring the sitting of the tribunal, it is the candid opinion of this tribunal to reiterate the fact that this tribunal is established as a constitutional body under Section 15, subsection 1 of the 5th Schedule, Part 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended. It was intended to be a special vehicle vested with specific powers with regards to the enforcement of probity and accountability in public service. These are well enumerated in the case of Attorney General of the Federation versus Abubakar, 2007, Weekly Report of Nigeria, Volume 44, at 130 at 147, line 25 and 30. This tribunal ranks and has coordinated jurisdiction with the federal and state high courts, and appeals herefrom lie to the Court of Appeal. See Section 24, 246, subsection 1 of the 1999 Constitution as amended. See also Section 16, subsection 5 of the Constitution of the Federal Republic of Nigeria 1999 as amended. By the provisions of Section 306, any order to handle administration by the provisions of Section 306 of the Administration of Criminal Justice Act 2015, the tribunal cannot accede to the request to halt proceedings. Our position is further reinforced by the decisions of the Court of Appeal in the case of Kalu versus Federal Republic of Nigeria 2014, 1 Nigeria Weekly Law Report, that courts that are of similar or concurrent jurisdiction are not bound to follow the decisions of each other. Therefore, a superior court of record cannot issue an order prohibiting or restraining the proceedings of another court of record. A court will not by injunction restrain proceedings of a court of coordinate jurisdiction. By Order 2 of the 3rd Schedule, Section 7 of the Code of Conduct Tribunal Rules of Procedure, that is under commencement of trial, this tribunal has caused the defendant to appear before it and stand trial. The defendant cannot claim to be unaware of this action, having been duly notified. The defendant, as a top-ranking political officer of this country, is expected to respect the constitutional provisions which he has sworn to defend, and at the same time, knowing the obvious implications of breaching the laws of this country. In view of this tribunal will continue with these proceedings, and accordingly, in view of the non-appearance of the defendant respondent, the tribunal orders the Inspector General of Police or the relevant security agencies involved to produce the defendant before this tribunal. In view of the foregoing, the tribunal hereby orders for a bench warrant to be issued against the defendant. Give us a date.
My Lord, we are so very grateful, my Lord. This is victory for rule of law, my Lord. Due process must be followed, my Lord.
Give us a date, please.
I will go places. My Lord, may we come back on Monday, my Lord?
Yes, defense? Yes?
Yeah, with profound respect, my Lord. We have listened with rapt attention to the tribunal's ruling. I don't know if the Lordship may direct that we be served with a copy of the processes of the ruling, so that we can study it deeply. He has asked for Monday. I wasn't here when the proceedings started today, and one would need time to study quite a number of things. But Monday is a good return date in the circumstances.
Learning NCN, if Monday is not convenient, we can make arrangement for you to have a copy of the ruling on Monday. Then we can come back here after then. Or Tuesday?
Tuesday, madam.
Tuesday is convenient?
Yes, madam, because Monday is the return date in the Federal High Court.
Yes.
So I have to notify them of the outcome of the ruling.
Yes. Prosecution?
My Lord, I'm sorry, sir. My Lord, I will have think Monday will have been convenient because it's for arraignment, my Lord, on Monday. And they have a copy of the charge, and they have been served with all the processes, my Lord. No, the Federal High Court proceedings cannot affect us here, my Lord, in view of my Lordship's ruling on this matter. So, my Lord, Monday is more convenient for me, my Lord, and for us here, sir.
We should argue about dates. I had earlier said Monday was okay. Your Lordship said that there is the opening of the legal year. Not that you said so, but that's what happened on that day. And that might not make it convenient for counsel, who have senior advocates that have been sworn in as senior advocates on that day. But nonetheless, we still have applications before this tribunal that have not been taken. And those applications, and it's a matter which your Lordships did not rule on, do not require even his presence, but for this ruling that says it requires his presence. It's a challenge on the jurisdiction of the tribunal, and it has to be taken first. Hassan knows that there will be no arraignment while a challenge on jurisdiction is pending. And so it's not, but it's a return date. So I don't mind Monday, and I don't mind Tuesday.
So we are now agreeing on Monday? Yes. Monday is what? Yes. Yes.
Your ruling has noted that the Senate President, who is the subject matter of the charge, is a very senior politician in this country. Yes. And we do learn every day. Some of the issues you have raised are quite germane. And in view of that high responsibility that he bears, I would be asking your Lordship to stay with respect on the ground that he will himself appear in court on Monday. So there is no need to put him at loggerheads. I'm giving that undertaking from So if my Lord can stay that.
Yes. The facts still remain the same. The most important thing is for the defendant respondent to appear. Yes.
My Lord, I'm sorry, sir, my Lord. I'm sorry, sir.
On my feet.
Yes, sir.
I've undertaken, my Lord, that I'll produce him. It's not a mechanism for wickedness or for making points. It's so that we follow due process. And your Lordship having ruled, I've said I'll produce him. I'll come with him on Monday. he should just support that instead of being mean about it.
My Lord, sir, may I be permitted to make some submissions in response of this last? This, my Lord, is not an act of wickedness or whatever, my Lord. The issue is that the court has already given a ruling that you should be arrested. Yes, sir. So, my Lord, the undertaking, with greatest respect, made by the senior advocate, is already belated, my Lord, because this court has already ordered a bench warrant had to be issued. So my Lord, that order cannot be put down by an undertaking or oral argument by.
It's all right. It's all right, Counsel.
Yes, sir.
Monday is what? Sorry? 21st. Matter is hereby adjourned to the Monday, the 25th of September 2015 for plea. 21st of September 2015 for plea. Well, it's all right. It's all right. We have noted that. It's all right. We have noted that. Yes. So we'll rise now.